So another round in the Zuma versus Ramaphosa legal battle will take place tomorrow. You may remember on the eve of the ANC elective conference last month, the former president announced he was launching a private prosecution against President Ramaphosa. Now, he's accused Ramaphosa of being an accessory after the fact, this in relation to Zuma's attempt to prosecute, also privately, advocate Billy Downer and journalist Karen Maughan. The National Prosecuting Authority has already said there is nothing to prosecute regarding the matter of a letter on Zuma's medical condition. Now, Zuma is disputing that this letter was a matter of court record. He says it was leaked between Downer and Karen Maughan. But tomorrow relates to Ramaphosa's attempt to have Zuma's private prosecution of him halted completely. I'm joined now by constitutional jurist Professor Koos Malan. Prof, thank you so much for joining us. You know, I have to focus every time I do these interviews because the legal devolutions of what is going on are so complex. Let's try and unpack it to really understand what's going to happen tomorrow and what's at play. Jacob Zuma is accusing Cyril Ramaphosa of accessory after the fact. What is accessory after the fact in general? Is it something that only crops up in private prosecutions, or can it be in criminal cases as well?
No, it's actually a basic principle, a basic phenomenon of criminal law. But I should add, it's actually one of the most difficult questions within the criminal law field. It can crop up in any criminal law case. What basically it amounts to is this. It is a form of complicity. In criminal law, we distinguish between two forms of participation in the commission of a crime. In the first instance, a person can be a perpetrator. That is taking part primarily in the commission of a crime. In contrast to that, or in addition to that, rather, you can also have an accomplice. Now, an accomplice is somebody who is not in the first place responsible for the commission of the main crime, so to say, but assists the commission of the crime and therefore assists the main perpetrator by promoting or by facilitating the commission of the crime. So this is basically what Mr. Zuma is alleging here. In other words, he alleges that the main crime, that is the leaking of the document concerning his medical condition, was leaked by Mr. Downer and Ms. Maughan. And then he says, well, basically, after that has taken place, Mr. Ramaphosa, in his capacity as president, assists them in escaping responsibility for the crime by actually doing nothing. That, in essence, is what Mr. Zuma alleges.
So, I mean, what I don't understand is surely the president is meant to do nothing in a situation like this. Otherwise, he'd be accused of interfering in the judiciary, which is a really massive problem.
Yeah. In this specific case, yes, you are mainly correct. That is interfering in the course of the judiciary, but not so much that, but actually interfering in decisions taken by the prosecutorial authority. It is for prosecutors, and in the first place, then for the director of public prosecutions decide on how to deal with prosecutions. Firstly, should there be a prosecution or not? And then secondly, once a prosecution is being instituted, it is up to the individual prosecutor or prosecutors to decide how to conduct the case. The president has nothing whatsoever to do with that. And you are perfectly spot on. Whenever the president somehow tries to interfere in such a case, in that case, he will actually be acting contrary to the Constitution. So, in essence, what Mr. Zuma and what his legal advisors argue, and I should say legal advisors actually not basing their argument on any sound legal principle, but what they are actually arguing is that Mr. Ramaphosa should have acted unlawfully and unconstitutionally. Mr. Ramaphosa also makes specifically this allegation in his affidavit, and I think he's spot on as far as that is concerned. Mm-hmm. I should also add the following, because I think that is important. Whenever you allege that someone is an accomplice to the commission of a crime, then firstly there must be a crime. Okay, you can't be an accomplice to a crime, promoting the commission of the crime if there was not a crime.
Yeah.
Now, in this particular case, there was in fact no crime. So in consequence of that, it is logically impossible to be an accomplice to that crime. And this is specifically the reason why I say there's really no basis for Mr. Zuma and his legal representatives' argument. And the final analysis, as far as I'm concerned, this is unfounded, it's frivolous, it's a question of a political machination actually masquerading as law, as a legal matter, but in fact it is not. There's no basis.
You mentioned the issue of no crime. I mean, we know that the NPA decided not to prosecute. He's launched this private prosecution against Karen Maughan and Biddy Downer. That matter is not completed. So when you say there's no crime, surely he would have to prove, he would have to be successful in that private prosecution before he went after the president. Is that what you're explaining to us?
Well, look, there's no necessity that the president has to, or rather that Mr. Zuma has to wait for a prosecution against Maughan and Downer. But the fact of the matter is that as things now stand, there's clearly no evidence showing that any commission in relation to the leaking of the document was in fact committed. The fact of the matter is, and I think in that regard the president is spot on, is that any information regarding the medical records of the president that was handed into court does in fact form part of the case record. And I should add, what was actually handed in by Mr. Zuma is actually nothing. There was almost no information included in that so-called health record. But the fact of the matter is, in the final analysis, the crux of the matter is that it forms part of the case record. So in other words, there cannot be a leaking of the information because the information was public knowledge already. Any one of us, any member of the public can have access to a court record. If you get access to such court record, including a statement, including evidence, including, in this particular case, information regarding a health record, it is not leaked to you. It is something that the public has broad access to as a question of right.
So my understanding is tomorrow that particular issue is not being dealt with. What's being dealt with tomorrow is the fact that President Ramaphosa is saying this is a ridiculous case. It needs to be disregarded, it needs to be interdicted, and former President Zuma is coming back saying, no, we've got a case. I understand a full bench is going to be hearing this tomorrow. Is it because we're dealing with two very high-profile people?
I suppose so. I think that is precisely the reason why the Judge President decided that it would be appropriate for a full bench to hear the case. I should add that my own personal view is that actually it's by far not a difficult case. It actually speaks for itself. But law must also be seen to be done, and precisely for that reason, I think it was decided, let a full bench of the court hear this matter and decide this matter.
Just finally explain the private prosecution process, because although the NPA has decided not to prosecute, the courts still oversee the private prosecution process. So am I right that it still takes up a lot of court resources, time and money?
Well, a private prosecution works on exactly the same basis as a prosecution being instituted by the state. The only difference, in essence, is that the prosecution is undertaken not by a state prosecutor, but on behalf of the complainant, who then appoints a lawyer to act as a prosecutor. Such prosecutor, has as a basis of right access to all information in possession of the possession of the police. In other words, in the police docket, and such evidence forthcoming from the police docket can then is then adduced as evidence in the criminal court. In the prosecution, in exactly the same way as a prosecution is dealt with if it's undertaken by the state. Precisely the same procedure also obtains. In other words, there is evidence in chief, followed by cross-examination, followed by the next witness, and so on and so forth. The state is the state's case, or rather the the private prosecutor's case is then concluded. And after that, the accused, if there is a prima facie case against him, is called upon or can decide to adduce evidence himself. So by and large, it is exactly the same kind of procedure that you have in a criminal case where the prosecution is undertaken by the state. But just to get back to your question, yes, it will take exactly the same kind of resources, exactly the same kind of time that a prosecution undertaken by the prosecutorial authority on behalf of the state would take up.
If we zoom out, and there are so many little side details, but if we zoom out, Advocate Billy Downer, of course, is the state prosecutor in Jacob Zuma's corruption trial, which dates back to the arms deal. I mean, we're talking 30 years ago nearly, over 20 years ago. The narrative coming from Jacob Zuma very much is that the judiciary is not impartial, that Billy Downer is the wrong man to be prosecuting him. What are your thoughts on how intact our judiciary is, bearing in mind that we've seen a number of broadsides aimed at specific members of the judiciary and the institution as a whole?
Well, look, in South Africa, the judiciary is actually a very hot seat for a variety of reasons. But zooming into this specific case, it is in a very difficult position precisely because it has been politicized to such an extent. But that in itself is by far not of any workings, any irresponsibility of the judiciary itself. The judiciary has been politicized as a result of the fact that Mr. Zuma, in this specific case, has made of the judiciary a political institution, which in the final analysis, in this particular context, in another context it might be, but in this political context, I think there's no claim that can be made that the judiciary is partial, that it is biased, that it has been captured by any party. I think in the final analysis, it's only one thing, and that is that Mr. Zuma has been trying to evade the court already for the past, it's now 15 years, 1.5 decade, or even more. And this is just the latest episode in this protractory of Mr. Zuma, who has long ago claimed that he wants his day in court. But when push comes to shove, this is precisely the one thing that he seeks to avoid as far as possible.
And thank you so much for speaking to us this evening, constitutional jurist Professor Koos Malan.